Sorry, Philip, you're here. Hello, and welcome to our conference this afternoon. My name is Kate Bush, and I am the coordinator for programs and services with the ALS Society of Quebec. It is my pleasure to introduce Maître Hélène Guay. She has been a member of the bar since 1988. She chose to develop a practice in the field of health law and is essentially orientated towards the representation of users of health services and their families. She runs a litigation law firm and represents victims of medical errors or their families, as well as individuals who are the subject of requests relating to their capacity or integrity. She advocates for the respect of people's rights before administrative authorities, such as complaints to local commissioners, coroner's inquests, professional orders, Human Rights Commission, Public Curator of Quebec. She has developed an expertise in representing seniors and defending their rights. Welcome, Maître Guay.
Very appreciated your invitation, Kate. Thank you so much for welcoming me, and so glad to meet with you all, and so glad that you are able to look into a topic you have selected. And I understand you wish to know a little bit more about some legal aspects that you are may be running into once a diagnosis of ALS has been issued. So my work is really to this afternoon with you is to focus on the different rights attached to the person receiving diagnosis, or even the person who is accompanying the person who's receiving a diagnosis. So this afternoon, we will look into different aspects. And my presentation you already see on the screen. I will make it available with the society, and I'm sure you will be happy to vision it this afternoon, and then after be able to have access to it and make notes. For questions, I suggest that you either send them by chat, by email to the society, or after the talk, we can have a discussion also with the issues raised further to the presentation. So the framework is as following. So we're going to run into the fundamental rights that are being more important. The issue of consent to care is really important, protection mandate and advanced medical directives, also the will, the driver's license, and medical aid in dying, and finally with a conclusion. So this being said, here are the fundamental rights I would like you to be aware of that are more of importance in a situation where a diagnosis of ALS has been issued. At any time these rights exist. At any time these rights are attached to a human person. And every person possesses these fundamental rights. Some of these have been are expressed here, such as life, meaning that every person has the right to life. Life may include for some people death, and life may include for some people improvement of life or palliation in a situation of life-threatening. So life is very broad, but in a sense usually meant in the legal terms as being able to live, to be alive. Security is one issue, is one important right also that is attached to every person to be in a safe place, in a safe situation, to be looked at in order to so that safety is ensured. So either the living or the people around the person. Integrity is much more attached to what is physical, but it also attached to what is psychological. So having a right to integrity means having the right to be eventually explained before there is a situation that will occur. Explain that there could be some difficulties, corporal consequences, psychological consequences. So integrity so the right to integrity will entail the fact that people around will have to fulfill some duties towards the person who, for example, has received a diagnosis of ALS and is in need of support in terms of moral, psychological, physical integrity. And freedom, the right to freedom, is a fundamental right. I have no need to describe this to you, but it's really a matter of choosing what is good for one's life, what is good when having received a diagnosis, what is good for that person. So options should be open to. And the other rights are as important. Dignity is really a subjective issue, a subjective right, in a sense that you do have your own evaluation of dignity, but in general, we do have still a definition for dignity that is more of a legal angle. Honor, and we will see honor and reputation. So these are rights that, meaning that you are not to be pointed out if you make your own choices based on your own values. So respect of honor and reputation is attached. Also privacy and confidentiality of information. So to reserve your rights to confidentiality of information that is attached to the diagnosis, to the consequences, to the prognosis. So these are important because they are in the charter and they are recognized by the courts as being major fundamental rights. Another element is also another element or another notion is a notion of autonomy. So just make sure that we're all on the same page with regards to this particular term. Autonomy means making choices, deciding for oneself. And what is important here is that every person is presumed able to exercise his or her rights, to exercise the rights. Every person is, and therefore, what is important is that the incapacity is going to be the exception. So even when having even when receiving a diagnosis, the diagnosis is not the person. The diagnosis is not incapacity. Incapacity needs to be demonstrated. It is the exception, and it must be shown. It must be shown by those who pretend the person is incapable. So the presumption of capacity is very important in our law, and only restrictions by law or by representation made by a judgment, for example, will limit capacity to exercise choices, to express wishes, and to be respected. So respected in the wishes, that is very important. Respected in our wishes as a person who is receiving a diagnosis of ALS means still being able to draft or to sign a mandate, to modify this mandate, whether it's a protection mandate, whether it's a power of attorney, also the possibility to change one's will, to modify, to adapt, considering the situation. And in fact, making decisions to modify these important documents might come, particularly when a diagnosis occurs. And a diagnosis of ALS might put pressure on making decisions on such. So if a mandate or a will or advance directives were signed before issuance of a diagnosis, it is always time to modify, to revoke, to change, or to make one, sign one of these legal papers, because these are legal papers. And one may, in part of what we recognize as autonomy, so as wishes of the person and liberty to exercise rights and be respected, is also to refuse to share information. Medical information need not be shared with everyone, may be shared with those we want to. Relationships may not be shared with everyone, may be shared with people who are new in our life, or have been long lifetime friends or not. So it's a choice one can make, and it's not because we're making these choices at this point in time that a diagnosis is being made that it's not appropriate or inappropriate or gives an idea that the person is turning the head around and not making sound decisions. No, it is still part of the wishes and an expression of desires for the coming months and years. The same applies to accepting and refusing a suggested treatment. One is still able to accept or refuse, accept this new treatment, accept this innovative treatment, refuse an additional dose, request an additional dose, refuse to participate in a research program or accept to participate in a research program. So these are still the decisions that a person may still want to decide upon once proposed, and should be part of your decision, and not left to everyone else, and not left to the knowledge of everyone. It's one thing to have and I'm talking to you on the legal aspects, all of the psychological support and medical support, professional support, other than legal, you will have to find, and you will discuss possibly. But ultimately, your decision is not a medical decision. It's a personal decision that you can base on information you have received. And knowing your rights, then you know that you may accept or refuse, change or revoke. And that is part of decisions that are personal and that have a legal aspect. So discussing with loved ones is always upon your decision to decide, and obtaining information from professionals, they are there for that, and you may want to solicit them to obtain more information. Another principle is one very important, that is protection of the person. So in the charter, we have this section 48, that calls for protection of handicapped person. And once a diagnosis of ALS has been issued, and the dependency that may occur in the long run or in the short run does involve a limitation of capacities. So quite quickly, people might obtain a medical report to the effect that there is a situation of handicap. What does this mean? What does this involve, legally speaking? Is that there is a specific protection towards people who are handicapped, in the sense that they should be protected against any form of exploitation. And who are those who are being protected, and who are those who are obliged to respect the protection, are obliged to have a duty toward the person who is handicapped? Well, it's the family and the persons who act in the stead of the family. So if one is residing, and not everyone is staying at home, some people might be staying in residences, then the persons acting in the stead of the family are thus under a duty to protect and security. And the family also is under a duty for protection and security. And usually this occurs only exceptionally do we see situations of exploitation. But it exists, and the notion, any form of exploitation that has been used in the charter refers to persons who have been made vulnerable by age or handicap, and who may be part of a relationship of dependence, whether it is physical, economic, emotional, or psychological, in the same way as all exploitation prohibited by the charter. So what we mean by that is that the idea that the person is handicapped might refer that there is a possibility of vulnerability. And once such a diagnosis is issued, it goes without saying that there is a shock, that there is going to be shortly or at longer term a possibility of vulnerability or fragility just by the fact of the diagnosis. So knowing that the family owes a duty of protection of security ensures a handicapped person or aged person that there is a duty on the person surrounding us, surrounding the person with diagnosis, so that there be no taking advantage from these persons towards the person who is handicapped. How is this going to be translated? Well, the more the relationship is one of dependence, the more the protection will be required, and the more security should be provided by those. So the greater the loss of autonomy, the more vigilance the people around shall ensure that there is protection towards the person. What does this mean in reality? Well, it's one thing to say that one is in security at home with a wife after the diagnosis has been issued, but what about people coming in and having the person to sign papers or having the person to donate? This is always, these are acts of, should be voluntary. These are acts that should not imply pressure on the person, that should be of complete independence of really a desire to act in this way, in this direction, and should not be because of a relationship of independence and the vulnerability coming out from the actual situation of the person who's learned, who's going through the diagnosis and the continuation of ALS developing into making the person more and more dependent, more and more in loss of capacities. So I think I don't want to be negative on this, but I want you to be knowledgeable that these situations may occur. And part of my practice is to defend people who are handicapped, age, and who are in situation of vulnerability. And I see a lot of these situations. And just to know that it's probably better to make decisions at the moment where you have a strong capacity to decide whatever energy there is, but there is a capacity to decide in terms of the expression of wishes can be made in the different documents, and then after not changing them upon such and such pressure. So I'm going to show to you a couple of assessments. The first one is the assessment of a person's disabilities. This is a system that you might know of or not. It's called the SMAF, that is for Functional Autonomy Measurement System. It's very useful in case of management, and it's really very much used when people are assessing, or professionals are assessing the level of disabilities. So they look usually in 5 spheres, 5 major dimensions of autonomy, that are activities of daily living, mobility, communication, mental functions, and more of activities in instrumental activities in daily living. So you can see what a short description under each of them. So what the process is a professional is going to assess, so evaluate in other terms. What are the capacities? What are the incapacities? So we'll come up with a portrait of the person's disabilities. At what level is that person now in time, January 17, 2023, what is the level of disabilities? And maybe in October 2022, it was different. And maybe in October 2023, it's going to be different. So it could be one assessment being made at times. Now it is divided in 29 items, divided in 14 profiles. So what is the goal of this assessment? Well, it's to enable professionals to know better the level, the person as well, and the people around the person. So in order to provide better services, better environment, better response to the needs of the person with disability. So it's well known that whatever the rapidity with which ALS will make its path, it will entail coming up disabilities. And these are the fields. So it's nice to know, okay, I'm here where I am, where do I stand, or where does my loved one stands. So in order to ensure that maybe steps may be done so that services are being provided to respond to the needs and to respond to the disabilities. I hope I'm not going too fast, and because I don't hear you, but I think if make sure you pick me back on the different items I'm covering if need be. Now, I did discuss with you right now the disabilities issue. I'm still coming into the issue of care. Why is that so? Because firstly, well, a diagnosis of ALS is of great importance. And in our system of law, the issue of consent to care is an essential component that is impossible to go around. In other words, we have, from the very beginning of our legal civil system in Quebec, we have always ensured that no one may be made to undergo care of any nature without consent. So we need a person's consent. And if the person is unable to consent, incapable to give consent or to refuse consent, then someone else will. But we always need consent to care. Professionals cannot consent for you. Persons are the ones who will decide according to the treatment proposed. As I was saying earlier, is it innovative treatment? Is it research? What is it that you propose? And before consenting, one should be asking, okay, what are the consequences of accepting this treatment or not, or not going into this way? Will you still be treating me if I don't accept to participate into the research project? Who is going to be my treating physician if you take your retirement or go on holidays? Who may I contact? So consent to care is something that one may affirm to accept or refuse once the information has been given. Because the information shall be given, it should be given in all transparency, and consent will then to care will then be issued, consent or refusal. So this is very important principle, and you're presumed to consent to care. There is a presumption that the person is able to consent, that every person is able to consent, starting from the age of 14. I say 14 because this is our law in Quebec. If one of the capacity of the person to consent to care, then incapacity must be demonstrated. And how is this? This is a second assessment. This is an assessment that's concerning the capacity to consent or refuse care. I'll give you an example. If say ALS is diagnosis is moving on, and the difficulties to provide care are made because of the problematic of loved one not being able to provide, and the environment to provide the care is just not reasonable for the person, and we need more services, and we need a law services in residence with specific services that will provide daily care, medication, food and hydration, that sort of services that would be required once the diagnosis has taken its way, and is the disability situation has taken its way. So it's not because it's coming very, very far that the person is deemed to be incapable. No, there should be an evaluation by the doctor. Okay, does this person understand? Yes, she does understand, or he does understand that there is a diagnosis of ALS. Yes, the care proposed is one that, yes, I would like to be treated as if I'm still a person who has access to health services, that deserves to be resuscitated because this is my choice. So that deserves to be to find a good place for being lodged. So the assessment of a person's understanding is conducted by a doctor who we will evaluate, well, in the circumstances, this person does understand what I'm explaining and does know the risks. To stay at home, it's impossible. The benefits of going to a long-term care institution is present, and the person accepts and does deal with that and is accepting, or to the contrary, refuses to go to long-term care because considers that the risks at home are not so big and has enough services at home to be helped towards the process of the disease being in place. So the doctor has to come up with this evaluation before concluding that there is incapacity to understand. Most of the time, capacity will stay in this type of disease, fortunately, even if one is unable to speak out, may use electronic means to communicate, even if the person is completely dependent, may still be able to express the desires. So usually capacity stays along the long term. And as I was saying, if it comes to the point that there is a need to obtain consent to care, so care that is, for example, blood transfusion, would it be injection or new medication or stopping medication, then we turn around once the incapacity to consent has been clearly recognized by the doctors, then consent from a person who may consent for the person with a diagnosis and the disease in place may consent for that person. And who are they? Well, firstly, either is the mandatory or the tutor. This means that there is a regime of representation. It may occur, it does occur, but it may not occur at all. And if this is not the case, then we turn around for consent to care to the spouse. And if there is no spouse, then we turn around to a relative or a person who shows special interest, like a caregiver, like someone who's been in touch with a person who has the diagnosis, who is able to express or refuse consent. And once that person has been identified, that person regarding care, only care, no other decisions, then that person shall act or is bound to act in the sole interest of that person. Always having in mind the sole interest of the person, ensuring that the care is beneficial for that person, it is advisable, the risks are not as important as the benefits that are being brought and are actually might be present. There's always a risk anyways in any care situation, but are in the balance, the proportionality of benefits would be higher than the risk. So when giving consent as a substitute consent maker, then that provides the person who has a diagnosis an aspect of protection and representation in matters of care that is essential. Thirdly, one may not be treated or lodged against their will. What does this mean? This means that even if there is pressure from social worker, from psychologists, from the neurologist, maybe you should go into the residence. Maybe this center would give you better care. If one is throughout its way of the disease is not happy with making a decision of living home and is still in possibility to stay at home, then may not be forced to be lodged, may not be forced to be treated. And if there is refusal, then CLSC is not able to force the lodging. But if they're still convinced that it is absolutely necessary, that there's no way that a person with the ALS at that stage, with the environment that this person has, is unable to stay at home, then they might go to court, obtain a court authorization. And at this moment, the person may be heard. And this is my practice in 2 words, that there be full representation of the person concerned by such a demand to the court. A judicial demand to force treatment or lodging is something one has to refer to a lawyer for sure in order to assert their rights. Let's talk about protection mandate. Just hold on, just take a sip of water here. We're talking here about another type of protection. Protection mandate is a document. It's a document that here, the one you see here is the one that is accessible and available. You can buy in the library or you can find on the web, provided by the Curateur du Public du Québec, who's prepared the document. It's well written, it's very complete, it's very clear. There are definitions, the way to complete the formula and the form. It's something pretty easy of access. Before this protection mandate was called mandate in case of incapacity. So if it was signed before, it is still valid. And what is important to retain with this protection mandate is that it is a contract. It's a contract by which a person of 18 and over who is capable will express his or her wishes. So their wishes to designate another person that will be called the mandatory. And that will entrust this person with the power to represent in the performance of all legal aspects concerning decisions in case of incapacity. So what does it mean? It means that it is a document whereby wishes will be expressed in terms of administration of property, administration of money, financial aspects, as well as personal aspects. So any and all legal acts, so including from the rent to the lodging to the care, therapeutic, non-therapeutic treatment, and therapeutic goal for different treatment. So it's very vast. It may cover all legal acts. And so therefore, it is a mandate in case of incapacity, meaning that it will be used and useful in case of incapacity. So then again, if there's no incapacity down the run, and this is in the majority of situations when a person has a diagnosis of ALS, then we will not be using the protection mandate because we may only use it once incapacity has been assessed and confirmed. So the idea of the protection mandate is really to protect and represent the person who is incapable. And so therefore, one may choose a mandatory with whom the person has good communication and that respect is on both sides. There are two valid forms of protection mandate. The first one is a private writing. In other words, it may be done signed in front of two witnesses. The content of the protection mandate is up to the person. It's coming from your own decisions, your own life situation. What am I going to decide? Well, how do I feel about making, if I'm in a situation of incapacity, what would I like to be in? What would I like to be around me if I'm incapable? What would I like my mandatory to decide if I was facing a situation of end of life, for example? So this is what within the protection mandate, and it can be made with the formula, the form I showed you earlier, or even on a piece of paper, defining who is going to be your mandatory, who will take all legal decisions in case of incapacity. Needs to be signed in front of two persons, the same place. And if signature is impossible, then there are possibilities that a professional confirms in writing signature is impossible, but this person is entitled to sign in place of that person who is incapable to sign. So this is possible, but however, need to have a professional confirmation of this incapacity to sign. Again, there's another form. Again, the protection mandate is also valid if it is notarized, so in front of a notary. So this is an act that is more official, more costly, and it's going to be, but is going to have also a need, either whether one situation or the other, whether one form or the other form, it will need to be homologated in front of by the court before being effective. What does it mean? It means that there needs to be a judgment. So not only is a mandate going to go in front in a court of law, if it's not contested, no one is there. It's just the court receiving the papers, the protection mandate, and the evaluations. Then the court will conclude validity of the mandate and the two evaluations, and when conclude it is necessary to homologate the mandate for the protection and representation of the person who has signed it. So the protection mandate, what do we put in this? Well, we put what we at our own discretion, what we decide that be our wishes and preferences. And the circumstances of each one's life is very different. You may have children, you may not have children, you may have property or not. You may have some major decisions regarding other people around you, such as, I don't know, a cousin who's been dependent on you because of the intellectual deficiency. So you want to make sure that once you are not able would you not be able to make decisions about the person, you would like this and this and that to occur, to consider, to take all good care of that person you were taking care of. You may have a property, or you may have, for example, a cottage, and you want the cottage to stay in the family, or to be sold, or to be given. So there's many things that we can think of in a protection mandate that may be decided. You may think, okay, I have always given that much money to every Christmas time. I still want my protector to take these decisions. Mind you, protection mandate, if it's ever homologated, it will go along the wishes. It's like a will that you want your wishes to be respected. The same with the protection mandate. So one may even write down, okay, I'll designate these two mandataries. I want them to work together in harmony. That is also some direction you want to give to the mandatory. And if one mandatory is not able to provide with the work and to represent me, then I would like this mandatory to find a mandatory that would be appropriate for me. I may designate more than one. I may designate also substitutes to the mandatory. So there are plenty of possibilities to prepare the protection mandate in order that it functions well once I'm not capable anymore to make decisions and the mandate is homologated. I may issue remuneration to the mandataries or not. It's not obligatory. It's not an imposed duty. It may or it may not, depending on our situation. So now the big question is, when do we conclude there is incapacity to make decisions? Again, although it is exceptional, I should address this to you. What is the basis? Well, the basis is that there is, at the very beginning, either an illness, an accident, or debility due to age. In our present situation this afternoon, we can think that there is no doubt that there is an illness that would take the start for evaluation. If, again, capacity is presumed, but if there is doubt about the capacity, then there could be an analysis of, is there incapacity to administer property, to make decisions? So that specific diagnosis and illness of ALS shall entail, in order to conclude to incapacity, shall entail that this illness does impair mental faculties or physical ability to express wishes. Okay, so when I say physical ability to express wishes, means severe and palliating to physical incapacity to express wishes is possible. We know there's many means. And so therefore, when we say physical ability to express wishes, means that we cannot obtain these wishes. We cannot obtain an expression of reasoning of the person due to the illness, due to the diagnosis been issued and the illness that's progressed. So it does affect the capacity of the person. So again, when it is the moment to determine if there is or not, then evaluations have to be conducted. Who evaluates? Well, there are two evaluations: the doctor's evaluation and the social worker's evaluation. And discussion could be made with a doctor. Why do you question me on this and that? Because the doctor is going to question a social worker as well as to orientation. What day of the year are we? What time of the year are we? Is it fall? Is it winter? The judgment. Okay, so do you really think you're able to stay at home? Don't you think you should be receiving services in addition, considering your condition? Don't you think you need this particular bed, particular equipment, particularly means to help you eat, to help you drink? And if there is an affection, or there's a problem with judgment, then that will entail a conclusion of incapacity, though that could entail conclusion. Memory is also one. Well, one cannot remember when one ate yesterday evening, or may forget the keys, but by memory, loss of memory means something substantial, like not being able to remember one's date of birth, or the name of the husband or wife, or the name of children. Affect refers to emotion. What is affect? Is being able to laugh, being able to cry, being able to express concerns, that sort of thing. And communication, capacity to communicate by any means. So ultimately, these two professionals, doctor and social worker, will come to, and after their analysis, will come to conclusion, and that will be part of their assessment of incapacity, and shall express also the extent and the duration. So usually it goes in one direction. Very rarely would it reverse to capacity, but it could. But usually it would not, especially in a situation of ALS diagnosis. Well, let's talk about AMD now. AMD means stands for Advanced Medical Directives. Again, another issue of care, and that's one big concern, and that is totally legitimate. Now, again, before signing these directives, one needs to be fit, so to say. One needs to be capable and free and independent. And however, maybe one might want to discuss the content, discuss the answers one will provide to the directives. So what we have in Quebec, and it's very unique compared to Canada's situation, what we have is the possibility to sign a document by which an adult capable of consenting may indicate advance wishes relating to medical care exclusively in the event that person becomes incapable of giving consent. So again, you have this notion of incapacity to give consent. What does it mean? Like the mandate in case of incapacity, it means that it will only be used if there is a conclusion of incapacity to consent to care. Only, not other than that. The mandate of protection we saw is only to be used and useful only if there is a conclusion to incapacity to make decisions and or administer property. In the case of advanced medical directives, it'll only be used if we have a clear conclusion of incapacity to consent to care, and also in decisions that we will see in a minute. So it focuses on decisions related to care, and it covers only specific types of care. It's not every type of care. And they are referred to only, therefore, only after incapacity has been concluded to. So there's going to be a conclusion of incapacity to consent. So there's going to be an evaluation, as we saw earlier, an evaluation of this incapacity to consent to care before we open up advanced medical directives. Now, why advanced medical directives? Why would you sign advanced medical directives? Well, they're meant to be used like if the person was there present, but because she's incapable to consent or refuse care, therefore she may rely on this paper, that is AMD. Professionals have to respect what is written. If there is no AMD, which is something that occurs in most of the cases, because a small number of people have signed, though there are citizens, there is quite a big number of advanced medical directives, but in all proportionally to the number of people who could have signed, it's not such a big number. But still, if the issue here is if there is no advanced medical directives, then it will be up to the legal representative, as we saw earlier, to decide. So therefore, the tutor, the mandatory, the spouse, or the close relative, or the person showing a particular interest. So once the medical directives are being being accessed and found to be useful, they have a binding value. That's why they are called directives. So they are directed towards medical doctors who shall respect them, who shall, and I say shall, they shall look into what is signed by the person who signed them and must respect them. It's not mandatory to discuss this with the doctor. It is suggested. It's not mandatory to discuss with the loved ones and the family. It is suggested. It's really a personal decision. It's nothing that is imposed by the law, by the professionals. One may be invited to think about it. Doctors and social workers may advance in giving information on this, but ultimately it's going to be one's decision and not the doctor's decisions. Usually advanced medical directives will be registered in the register of AMD, but if it's given to the doctor, then it's going to be in the medical record, which is an option that can be thought of because it's more readily accessible. So two ways to make the directive médicale avancée. So this stands for DMA stands for AMD. So it's directive médicale avancée or advanced medical directives. One way is to complete the form with RAMQ and send it back to RAMQ, or do it with a notary who will, both of them will be registered. RAMQ has the register for AMD, and notaries have a specific register as well. Register, why? Because then it enables the doctors to access the AMD and to respect the AMDs and know if there have been or not AMDs written by the person. Also have to remember they are very specific, as I was saying earlier. Why is that so? Because the legislator has decided that it's going to be only in 3 situations and in 5 care clauses and 5 care specific situations. So 3 situations when advanced medical directives will be looked into and see what are the wishes of the person. So if we look into, if we apply one of these 3 situations, can we think of any of this situation that could attach to an ALS diagnosis? Well, end of life situation is certainly some situation, one situation that will come up. So end of life situation, provided that the person has become incapable to consent to care, then the advanced medical directives would be accessed by the professional. The two other situations refer to severe and irreversible impairment of cognitive functions. I will not extend on this because I would consider that they are less of importance to occur in matters of ALS diagnosis. However, if we look at the 5 clauses on the other side, then the 5 care clauses are referring to 5 situations involving, so to say, survival. Failure of heart, failure of ventilation, failure of renal failure. These are the 3 main vital organs that are at stake. And if they are not being cared for, then the collapse will occur very soon. So what is meant by the advanced medical directive? It's meant to permit to the person signatory to decide in case of failure of this organ, such as the heart, do I want resuscitation or not? In case of failure of capacity to breathe, do I want assisted ventilation or not? In case of failure of a renal function, do I want renal dialysis or not? So, and again, to feeding and hydration. So what it means that when filling the form, there is a possibility to decide to project oneself into the future and say, okay, if I was at the end of life, if it was going to occur, say, in 2 years from now, what would I like? What should be done if I become incapable to say yes or no to care, yes or no to ventilation, yes or no to dialysis? What would I like the doctors to do for me? So I may decide in advance and check yes or no to each of these care clauses. You might have even signed it already, and I'm just ensuring that your understanding of your own decision is clear and complete. Next element is the will issue. Why prepare will? In a way, like the protection mandate, like the advanced medical directives, it does ensure wishes to be respected. In that case, it's after death, not after incapacity, not during life. So it's after death. It might also reduce conflicts between the heirs. It might suscitate conflicts, but conflicts would probably occur if they have already started in a way. But it clarifies in one's mind the decisions that will be taken after one's death. And it clarifies for the heirs how this is going to, how is the split going to occur? Whether 20% will be to that organism, 20% will be given to Centraide, another 10% will be given to the parish that I've loved, another 10% will be given to my cousin who has the difficulties in life, and I was the tutor this person for that many years. So it's one's decision, and well, it's one, again, one should be totally independent before preparing. It permits to identify who are the heirs, who is the liquidator, who will be the substitute liquidator, who will inherit or not. So this is how the distribution of assets will be done, and giving also some instructions to I'd like you to do this, I'd like to do that. So prepare in advance and discussing with the loved ones how you articulate all this, and even express, being fully transparent and discussing with the children that the way it's going to occur, and it might come sooner than later, and you want to fix this and you want this to be clear to everyone. This is the way I would like things happen after when my death occurs, and make sure you're all in harmony. And why not put it down? The document, the will document, is something we refer to. It's a legal document that is very important, same as a protection mandate, and it will stay and it will have to live with your wishes. And any adult is free to make a will. Even the minors are entitled to make wills. Everyone is presumed to be capable to prepare, to sign, to modify, to revoke, to replace, except that once, like the other documents, once it is signed, it should not be changed at home with personal notes. Because if it's been signed Montreal, January 17, 2023, and it's changed in February 2023, without having the signature of the witnesses to that change, and because it's been signed in front of two witnesses on January 17, it will not be valid if it's changed afterwards. So one needs to be sure that to think about it, what changes I would like to make, and if absolutely necessary, change it. If it's necessary, why not? And if the mind is ongoing and that's a possibility, that they be changed. So make sure, however, and that's a caution I bring because in my practice, this is what I see the most, challenges based on the fact that the document, whether will, protection mandate, was not signed when the person was capable. In other words, when it was signed when the person was incapable, and the contestators bring up medical evaluations saying that the person was incapable, and the doctors has assessed, and the person did not know how in which direction to go, and was influenced and affected by pressure. So it's probably a good thing to remember that maybe do the papers now and prepare not to change them in a short time coming up, so that the intentions of the wishes are confirmed, and if absolutely necessary to change them, yes, but make sure that if it is changed, it's not in a period of important fragility or vulnerability. And the forms of will, yet we compare with the two others. The protection mandate we can make it ourselves and sign into two witnesses, and we do not need to read the content of the documents we sign. We only need to have the witnesses. The advanced medical directives, you need also to sign in front of two witnesses. As far as the wills are concerned, there's a holograph. You need not sign in front of anyone. You have to make it you have to sign it yourself, write it yourself, and sign it yourself. So the risk of loss is present if you keep it at home, because it's not going to be registered unless you give it to a lawyer who may register it. That will put a reference in the register, and that will therefore make it clear to third parties that there is a will that has been signed, say January 17, 2023. So a holograph is without charges, except for the registration if it's done. Maybe one doesn't have legal advice, but maybe one knows what to write in the will. And it might be necessary to obtain probate. Probate means verification of the will, because it's holograph. At times we have seen the situation of having a need to probate. At other times there was no need, because there was such a consensus that there was no need for that if everything went very well with the conduction of the execution of the will, and the liquidator provided with everything that was necessary. Because in the holograph, one will possibly nominate a liquidator and distribute, and ask the liquidator to distribute this manner. So that's one form. The next form is made in presence of two witnesses, and the third form is notarized. So again, the two forms we already know, made in front of in the presence of witnesses. Of course, these witnesses, it will be a little bit more costly if you run it with the notary. But if it's in the presence of two witnesses, it may not be very costly. It might need probate. It should be registered by a lawyer, so that there is a possibility to access and see, oh, is there a will existing at this moment? and it might even be done in front of two witnesses at a lawyer's office. The validity is the same, whether it's in front of two witnesses or if it is notarized. The content will vary, probably because the notary will insert all sorts of clauses that might not be necessary. But it's one's choice to go with the notary and have all these documents made or not. And if not, well, if it's in front of two witnesses, one needs to remember that the witnesses shall not be beneficiaries in the will, shall not be heirs or legatees in the will. The same applies for the protection mandate. The witnesses shall not be beneficiaries in the mandate, because in the protection mandate, I could say, you take care of the cottage, you take care of the children. And it might be the children that we are referring to or giving the duty to act as mandataries. And we don't want the witnesses to be in conflict, right? So you don't want the mandataries to be witnesses. You don't want the heirs and the legatees to be witnesses to the will. So that's an important element to remember. ALS and driving, well, as you know, driving, the main issue is security. So for one's safety or the safety of others, one should report to SAQ any change in health status that may affect safe driving within 30 days of the diagnosis. So when to report, how to report, this can be accessed on SAQ. The regulation says 30 days from diagnosis. So the medical certificate will enable a person to continue driving or not. So it's really with the declaration that is usually via a letter that is the decision of SAQ will come back. So the timing of the diagnosis is important, because once the ALS diagnosis is issued, if it's communicated to SAQ, then SAQ might come with the decision of suspending or putting in conditions to the driver's license. So the main goal here is not protection or representation, but rather safety of oneself and others. And there's the other issue with the driving permit, etc., and yes, transportation, is that there is a possibility to ask parking permit, adapted vehicles. These are steps that are probably more in the long run or more strenuous and more difficult to fulfill. In any case, all these steps with SAQ, with or without a diagnosis, are always very strenuous, I would say. But if it's necessary, and it is important that you know that it does exist, the request to obtain what we call a vignette. So the vignette, it might be useful. Some people don't request it, but it's probably a good idea that not only to know that its existence of the possibility of requesting, but also to have access to it. So it facilitates transportation. It facilitates recognition of a particular situation that that entails respect. So access the SAQ. The very last page, you will have references, and this document you see on the screen at the moment, you will have access as a PDF document after presentation. Then one last point I want to refer you to is medical aid in dying. And this is, you've heard about, I don't think I need to spend so much time to define. It is care consisting in the administration by a physician of medications in order to relieve, to relieve pain, but to relieve the suffering, and that will hasten death. not only to relieve pain, but we all know that it will hasten death, and that's one of the goals. So it's medical aid in dying, so it's care. So in order to access to medical aid in dying, that cannot be, the choice cannot be made in advance, not at this moment, and probably not in the very, very near future. One needs to be, firstly, an adult, secondly, covered by REMQ, thirdly, capable of making decisions. What we discussed a lot, I presented a lot to you, capacity to consent to care, suffering from a serious incurable disease, which would be the case in case of ALS diagnosis, advanced and irreversible decline in capability. So at the very beginning, once the diagnosis is issued, it's usually not the case. So this condition is not fulfilled. It might come sooner or later, depending on the development, depending on the person. So maybe at one point in time, these conditions, these 5 conditions will be filled. The 6th condition, but not at the very beginning. The 6th condition is constant and unbearable physical or psychological suffering, which cannot be relieved in a manner the patient deems tolerable, by way of sedation, by way of palliative care. So what it means that psychologically it's unbearable to continue living in these conditions. We all know, the person might know, okay, I still have a few months to go, but I feel like I would like to end this now at this moment, because I feel like I'm comfortable, I'm ready to go, I'm ready to say goodbye to everyone. So it's a really personal choice that might come from one's situation. Legally speaking, there are 6 conditions that have to be responded to for sure. And as I said, it's not at the very beginning that once the diagnosis is issued that the 5th and 6th conditions are fulfilled, but they, depending on the evolution, they might come to be fulfilled in a short future. So how steps for medical aid in dying? Well, usually one will express the choice to the doctor, to the neurologist. The doctor will fill the form. The doctor and the person concerned with the diagnosis will also fill the form, date and sign it in the presence of a professional or a social worker, and of an independent witness that will not be beneficiary in the will, and that witness will also sign it. And in the event there is incapacity to sign, then another person may sign for the person who wants to, who is unable physically to sign the form for requesting or asking medical aid in dying. Second step will be before the doctor administers. Well, before once the demand is made, then it goes to a request to the doctor. The doctor must then, before anything else, consider to fulfill his obligation, which is to ensure that the consent was free, independent, that the suffering is persistent, that the demand is persistent also. It's been repeated, that the person has had the opportunity to discuss with the health professionals, that the person has had the possibility to discuss with relatives if that person wishes or to do so or not. Another step, the doctor needs to ensure that the person has had discuss the application with the person they wish to, and also obtain a second opinion from another doctor. Doctors must be independent with their evaluation, and once this is all undergone and concluded that it is possible, then the doctor may therefore administer at the date and time that is being agreed upon. So in conclusion, there are many multiple legal issues that we can think of. These were some of them because there could be additional ones. The idea behind these legal documents or these decisions that could or should be taken are really in order to ensure respect of the person who is still capable or who will entail incapacity. The more you know of your rights, the better it is, and therefore it should provide you with more confidence in decision making. And in case, you should not hesitate to consult a professional to help you, whether a health professional, but legal professionals, we are there to help you out and enable you to express your wishes and make decisions appropriate for you. So I thank you very much for your attention, and I cannot wait up until you do have questions or discussion on these topics we had as a presentation. Thank you very much.
Thank you. Thank you, Hélène Guay, for a very enlightening presentation. There is a question in the chat. If you suspect abuse of some kind, how do you signal it? So if somebody is suspected of being abused, how does it get signaled?
If the person suspects to be abused, the best thing is to probably be in touch with the health or social services provider and express the concern to that person. And so express verbally or in any manner the discomfort brought by the situation. They are capable to react. They are capable to understand more and to provide with more vigilance and appropriate reaction. Because the concern could be a reading that is temporary or a reading that is due to a particular circumstance. I don't say that we should. I would say that there is not necessarily a tendency to suspect abuse, but usually we tend to think that people are acting in good faith or acting with good intentions. But the more the person is dependent and the more the person has a preoccupation with a concern regarding abuse, then professionals should act actively. So if they don't know, they will not. So they are the first door to knock at. And myself, as I do represent aged people and handicap and people vulnerable and fragile, I always think, and that's what I tell health and social professionals, I tell them, if you have a reaction and you have a patient who's expressing to you a concern, although you may think, oh, people around him or her are very good and they're taking care and is just thinking of other things, what I say is have a thought that this person is not inventing. Maybe the others are very good, but the person who's telling you this has a real concern and has something you should address. Because if she does so, or he does so, I say I do have a favorable privilege. Can you say that?
Mm-hmm. Yes.
Yes, favorable privilege towards what the person is expressing to me. My clients are expressing to me this situation of abuse, and I always give them positive privilege.
Benefit of the doubt.
Exactly. I was looking. Thank you so much. Benefit of the doubt. Okay. And if I'm wrong, I'll be wrong. Worst that can occur is that I'm wrong, and that's no problem. But the problem lies with the person in front of me. So if that person is feeling like not comfortable, okay, express also that I have a concern, like to talk with you, but only with you, because maybe the close person or the caregiver or the loved one is around, and I don't want this. I want to tell you because I would not feel good. Can we have a talk or make it sufficiently clear so that the professional knows, maybe not only one professional, maybe more than one, so that they may talk around themselves, say, hey, that's just, did you see that? Did you see his expression? That's a new expression. What is going on? And they have education to find abusive situation. So that would be much. Of course, if one is having people all around and the family members, and one family member is thus invading into the situation, and one may think, okay, I'll tell my daughter because my son is not behaving appropriately. It could be, but it's possible. It depends on the dynamic, but the independency of these people are not always easy. It might come to more of a conflictual situation, but I would tend to suggest that to talk to the professional.
Okay, thank you very much. Does anybody have any other questions or comments to share with Maître Guay?
This is Phil Alone speaking. I just want to thank you, Hélène. That was a very, very good presentation. The good news is I look like I'm pretty much along the path of getting all my legal stuff in order. The only thing I have left to do is the advanced medical directive, which I think you gave really good direction and clear instructions on how to do that. And I think for anyone who is going to listen to this later, that little thing about the handicap parking pass is critical. Honestly, it is a game changer. I now do not drive, but I still have my certificate, so I am able to get good parking wherever I go. So I think that's really important. There's not a lot of good things to have with ALS, but getting good parking is one of them. So
That's great to hear, Phil. Thank you very much.
but thank you, Hélène. Very good. And Kate and Lee, thank you so much for today. That was good.
Wonderful.
Well, thank you, Philip. It's our pleasure. Thank you very much for sharing and for this and attending. Yes.
Thank you. I think that we are done then. So thank you very much, Maître Guay, for your presentation today. And I hope everybody who's listening to this later enjoys and gets as much information as you need in order to deal with legal issues related to ALS. Thank you very much.
Thank you very much.